From Studio 226 in Orlando, this is Aging Smarter. Aging Smarter is a podcast focusing on making it easier to grow older, to prepare for the future at any age. We aim to educate, entertain, prepare, and amaze you about your life's journey, regardless of your age. Because regardless of your age, you are aging. So it's best to age smarter. I'm your host, retired and former circuit judge Jose R. Rodriguez. Welcome, everyone, to this podcast we call Carving Out Undue Influence. The Carpenter 10 Factors Preserving Beneficiary Rights. Today I'll be asking Alexandra Acosta, a third-year law student at Barry University Duano Andreas School of Law, some questions about how undue influence can affect beneficiary rights in wills, trust, estates, and other transactions, such as, the transfer of property by deeds. Also, thanks to her research, she will offer some information to help us break down the legalese for our listeners who may not be lawyers or law students. Remember, this podcast is offered for educational and discussion purposes only. This podcast is not intended to be offering legal advice because your questions about your particular situations may vary. Please don't hesitate to contact a licensed member of the Florida Bar for your questions about your particular situations. Alexandra.
Yes.
You're in your last semester at law school, and you're editor-in-chief of the Barry University Duano Andreas School of Law Child and Family Law Journal. Now, thank you very much for accepting the invitation to come and talk about this rather complicated, maybe we're not going to make it so boring, legal topic.
Well, thank you, Judge. I am very excited to be here and even more so to share with our community more about this topic.
Great. Awesome. Fantastic. Let's get going. Anything you want to share before we go on into some fun definitions?
Sure. I thought I could start by providing a little context as to how law students are first exposed to the topic of undue influence.
Oh, context is good. And law students, I remember that well, even though it was a long time ago. So go right ahead. Hit us with it.
Sure. Okay, well, first, as a law student, at least at Barry Law, we started with our contracts class. It was a 1L fall, and we covered undue influence. And in this law school course, we discussed the concept and followed then in a wills, trust, and estates course. For law schools, usually you have that in your second or third year. And also now, currently in our guardianship course, which I'm taking from you, Judge, we are discussing the topics of undue influence there. So, however, for those who are not in the legal field or studying law, many of us have or will be exposed to the concept of undue influence, even if, luckily, hopefully, never experiencing it ourselves. One of my examples is the popular movie Knives Out. So if you have not seen Knives Out, have you seen Knives Out, Judge?
I've not, but I've seen another one, which is basically is the same, called Traitors. And it's just about manipulation and lying and getting away with it. And again, making people do things that may very well be against their best interest.
Yes. So similar to that movie, Knives Out, it follows a plot where it revolves around a wealthy novelist who then unexpectedly leaves everything to his caretaker, his nurse. And the film highlights the themes of secrecy, manipulation, suspicious circumstances, and the kinds of red flags that courts look for in undue influence cases.
Wow. Thank you. That's great context. I think we're ready to jump into the topic now, don't you? Let's start with an easy definition. Alexandra, what's a testator and what do they do? What is that for those of us who don't know what a testator is? Is that like somebody who takes tests or gives tests?
Well, as the word might imply, no, it has a different definition. A testator is an individual, it's pretty simple, who passes away or dies leaving a valid will. So we can think of them as the author of an estate plan, for example.
Aha. And who benefits from that will?
Well, that would be called the beneficiary.
Oh, that's perfect.
Yes, which, as the name would follow, it is a recipient of the estate plan. It is the person or the entity chosen to receive the benefits.
I see. Now, if someone interferes with those rights, what do we call them?
Well, that would be, shockingly, we would call them a wrongdoer.
Not the interferer, but the wrongdoer, because he's doing wrong.
Correct.
Okay.
So I'll define it. It's probably self-explanatory, but a wrongdoer, as implied by its name, this would be someone who commits an unlawful act that violates another's rights.
Oh, and in court, who becomes the defendant?
So a defendant is the party against whom the legal action is brought. They are the accused in a criminal case or the one that's being sued in a civil case.
The suee, not the suer.
Correct,
I
yes.
guess. Okay, excellent. We've established a solid foundation now. Let's move into undue influence and how it's defined. Let's take, for example, contract law. Well, how is it defined in contract law?
So contract law, again, if you're a Berry Law student, you likely had that your first year. It deals with a few prongs. The first being, is there a confidential relationship or a dominion? Second, is there unfair persuasion? And then third, inducement. Fourth, is there awareness by a third party? And so we can think of these factors as asking, was someone pressured into making a promise that they wouldn't have made otherwise?
I see. So basically, it's the forced decision-making. And then basically what we're dealing with is we're dealing the intellectual or the mental ability of the individual to form an independent judgment.
Correct. Yes,
I
Judge.
see. So that's helpful. How does that look in wills, trusts, estates, and the transfer of property?
So in wills, trusts, and estates, undue influence means the wrongdoer exerted such influence over the donor that it became
It overcame
the donor's free will. So they're essentially rewriting the script of the will by overpowering the testator's true intentions.
Oh, I see. So they're like, move away. This is what you want to do. Not what you want to do, but what I want you to do is what you're going to do. And that's what gets done.
Correct.
Did I say that right? Okay.
That's a great way of putting it.
Okay.
To clarify a little further, we have a test that's helpful. It looks at a set of factors that assess whether there is susceptibility, opportune disposition, and whether the result itself was a natural. And these are all areas of focus in present cases today. They're analyzed under these initial set of factors, Judge, but we have some additional factors that are utilized by the courts to understand whether undue influence has occurred.
And I read them in the Florida Bar Journal. If anybody has an access to the Florida Bar Journal, they talk about 3 additional tests.
Yes, they do.
And all of this is very fact specifics. That's why if you've got a situation where it smells like undue influence, best thing to do is to contact a licensed attorney and run it by them to see what they think.
Yes, Judge.
So what's that? What are those factors? What's the test?
Excellent question. So the new test, it is broader, and it simply asks whether suspicious circumstances exist, like secrecy, haste, changes in attitude, discrepancies in the present will to prior wills, or an unnatural disposition of the property.
Excellent. I'm beginning to think about a couple of cases that I had when I was sitting on the bench, and I won't elaborate until we get through all of the factors so that everybody knows what the factors are and then see what I was confronted with as a result. Because this stuff does happen.
It does.
In real life. And I hate to say this, but in my experience, it's about greed. It's about folks that want to take more than, well, what really should belong to them, or what is the will of the testator, the person who goes ahead and writes the will to give up their property. So let's talk about mental capacity. What is it that a testator requires as far as mental capacity is concerned?
So the testator must have capacity, and the courts look at it occurring at the time of execution. So the burden then shifts to the individual contesting the will or the document being transferred by the deed to prove a lack of capacity, undue influence, fraud, or duress. And if the testator lacked capacity, the entire will or transaction then fails.
What if the person has already been found not to have capacity as it applies to a guardianship case. Is guardianship linear? In other words, does capacity fluctuate?
Capacity does fluctuate.
Kind of like
Correct.
a
It is not a
wave?
linear, like a wave.
Right? So sometimes you may have capacity at the top, but then at the bottom of the wave, you may not have it.
Correct. And that's why it's so important to look at the time of the will's execution to determine capacity at that moment, not moments prior.
I see. So Florida courts have a famous case on active procurement, don't they? Can you explain the case and, well, which our podcast has been titled under?
Yes, of course.
Carpenter.
Yes. So in the precedent case, N. Ray Carpenter, it's a 1971 case. The Florida Supreme Court listed 7 Carpenter factors which help the courts identify active procurement.
And you mentioned help because the court cautions us that even if those 7 factors are present, it may not rise to the level of an active situation that has to be set aside because undue influence occurred.
Correct.
They are suggesting that
Correct.
these are things to look at.
It is, yes, correct.
And
Determined
that's
by
that
case by
case.
case. Yes. So the factors they're not elements. As law school students, we know the difference with elements, the requirements. Factors are considered as a whole, determined by case basis. And these factors, as the court has held, are considered warning factors as to whether undue influence is present.
It's kind of like little red flags.
Correct. Exactly.
Warning, Will Robinson. That's from a sci-fi reference. Please forgive me. An oblique reference to a late last century Lost in Space saga.
Add it to the list of Knives Out.
So, can you tell us a couple of those factors?
I would be more than happy to. So we have one of the factors being the presence of the beneficiary at the execution of the will or the document. Recommending an attorney is another factor that courts looked at.
So you've got somebody who's telling you got to use this attorney, and
Correct.
then they sit down when you're doing the will.
Correct. Another factor is giving instructions to the attorney on how to operate and navigate the agreement, securing witnesses, the safekeeping of the will afterward. All of these factors are taken as signs that the beneficiary may have had too much control over the process.
All right. This is the time where I'm going to go ahead and share the situation. I had 2 similar situations, and in one case, I cannot emphasize how important it is for lawyers, if you're hiring one, for your lawyer to have read and understood N. Ray Carpenter. In both cases, I had one lawyer that had read the case, another one that didn't, and it became very obvious during the hearing. First case is a young woman whose mother has passed away. She is asking the court to accept the will and to have the will accepted as a valid will for that mother to be administered. There is a second husband, who is objecting to the will being accepted. He was an older lawyer and remained very quiet throughout the hearing because the younger lawyer started asking questions that went to each and every one of the factors. Let me explain what happened. Mom gets taken ill. The daughter knew that she was out of the will. The husband was part of the will. Not her father, but her stepfather, with whom she did not have a good relationship. What happens next is that her mother is taken to the hospital. The daughter finds a way to go ahead and get her boyfriend, who is a paralegal, to go to the hospital to do a will that had been obtained through a website. The daughter also goes ahead and gets one of the witnesses as the next-door neighbor lady. The next-door neighbor lady shows up to the hospital. Finally, a notary is procured also by the daughter. I mean, I'm sitting back and I'm listening to all of this, and I turn to the lawyer and say, "Counsel, have you read in Ray Carpenter's estate?" And the lawyer says, "No, should I have?" And I shrunk in my seat and I go, "Not now." It's kind of, and inside my little voice says, "No, it's too late now." But here's what happened. Oh, that night, Mom redid her will with a boyfriend presiding over the will, the notary, the witness that had been brought. However, the one missing factor was that the daughter was not in the hospital room where the witness was being where the document was being executed, but she was outside pacing the halls, as was the stepfather husband. Well, what happens the next day? Mom passes away. I had to make findings based on what had been offered, based on my knowledge of the factors, that at this point it was very obvious because there were two other insurance policies where at the last minute she contacted the insurance company to switch the beneficiaries to her. So I knew what was up. And I knew that this was not what the mother had intended, and it was the last minute when she was in a very weak state that she was in. And, I mean, they took advantage of her. So I went ahead and invalidated the will. The other situation was a transfer of property by a deed. This was kind of sadly comical because the witness, again, who had done the effective deed transfer was another paralegal that went to the same church. The young man who was going to take over the mother's property wound up finding her at church, wound up getting the notary, and the lawyer that offered the deed to determine it valid did not ask any of the questions that were dealing with the factors under Carpenter. And I just furrowed my brow, and I was just wondering, what is this trying to do? What is going on here? Well, guess what? The lawyer for the opposing side started going down 1, 2, 3, 4, 5 of the factors.
Of course.
And I said, "Counsel, have you read in Ray Carpenter's estate?" And he goes, "Oh, of course, Judge." And sure enough, I had to find that the deed was transferred invalidly because, again, all of the, if not most of the factors were included. So it does happen, and it happened to me in a span of 3 years twice.
Those are excellent examples, real-life examples.
It's real. It happens. So you have to be aware. And again, if the mother had capacity, I think we might be at a different state. But the point was that she passed away before she had a chance to even speak. And all she did was she signed a will that the daughter and the boyfriend's daughter had constructed, unfortunately and unfairly. So tell me, do those same factors that that were litigated back in 2015, 16, 17 are still the same?
So the answer to your question, as often law school answers are yes and no.
Okay.
It depends.
It's a maybe.
A maybe.
It depends.
Right. Well, so yes and no. So we still look at those 7 factors that Ray Carpenter point out, and in addition to those 7 factors, we have an additional 3. So the additional 3 indicators or factors that courts will look at are number 8, isolating the testator. We'll have case law that mentions letters of family members going to the decedent where the beneficiary is preventing those letters from actually being delivered. We have the 9th additional factor, the mental inequality between decedent and beneficiary,
Right.
where if the beneficiary is very headstrong and the decedent has a reputation for not being so, that is one of the case law examples of this additional factor. And then the 10th factor is the reasonableness of the will's provision. So
Right. And in my case, what we had the daughter wanting to push aside the stepfather, and it was very, very clear, very obvious.
Correct. Exactly.
So the sad thing is that when you're dealing with Carpenter estate type factors, it's always a litigated situation. I have not seen a situation where litigation was not necessary to overturn something of that nature.
Correct.
So, well, this is great information, especially the additional factors. Now, let's bring in some case law. What happened in Newman versus Smith?
So in this precedent case, Newman v. Smith, we had a beneficiary that was isolated by the testator by, like the example mentioned earlier, intercepting letters and then denying access to the family. And this cut off, as would follow, the testator's lifeline to their loved ones and was an example of the 8th additional factor. And the isolating of the testator was the person whose will had been drafted. So that is one of our case law that adds to the additional factors.
There's another case out there called Peacock versus Du Bois.
Yes, sir.
What's that all about?
So,
and how does that factor into the factors?
So this case addresses that 9th additional factor, the mental inequality. And in this precedent case, the court found undue influence because the decedent was easily influenced, while the beneficiary was strong-willed and mentally superior, like we mentioned before. And the court found that this was somewhat of a mismatch to where the person vulnerable was being overcome by the dominant, and it was undue influence.
How about Donnelly's estate? In Ray Donnelly's estate, that's out there also.
Another one, yes. So this precedent then, the court considered whether a will's provision were reasonable or unnatural, and ultimately they upheld them as not unreasonable given the circumstances. So this case would go towards that 10th additional factor, reasonableness of the will provisions, and the court essentially was asking, does this will make sense in light of the relationships involved?
Well, we've talked about cases. There are also statutes that cover this area. So what are some of those statutory authority and how they address undue influence from a legislative standpoint?
Excellent question. So we have, in 2002, Florida amended its statutory authority to create a presumption of undue influence. So this shifts the burden of proof as a public policy against abuse of the fiduciary or confidential relationships, which is important because oftentimes we're dealing with a decedent who is no longer present to speak to their intentions or the dynamics around the drafting of the will and execution. So we have other case law. We have Hack v. Janes, which confirms this presumption doesn't just vanish when rebuttable evidence is offered.
In other words, you've got a presumption rising. You've got to offer credible information, reliable evidence that is admissible to refute that presumption.
Exactly.
Okay? So what else do we look for in the refutation or the rebuttal of that presumption?
Well, so in addition to the examples that we've discussed with the case precedent, it also does extend to children's rights. And this is a textbook example would be when a surviving parent or step-parent has a confidential relationship with the deceased and therefore can influence or manipulate themselves into that will or other document that may be to the detriment of their child.
I see. Well, you know what? You hearken back to memories of guardians who basically overstep their bounds and basically do the same thing with individuals that are, found to be incapacitated. But we'll talk about that in the guardianship class.
Yes.
But it is not to be forgotten that in guardianship situations, undue influence and there are some cases, by a guardian can also be a parent.
Yes.
All
So
right.
with the precedent cases, like you were saying, the courts will look as to whether, a parent has isolated the deceased from the
Yes.
children, disparaged them, or created unreasonable provisions, such as leaving everything to the surviving parent or step-parent and then nothing to the children.
It reminds me of Shirley Temple and Jackie Coogan,
Yes.
who child actors were left with nothing because their parents took their money.
Yes.
Back in those days, there wasn't the protections that we have now.
Sadly, no.
This
Right.
being statutory and case law protections that have evolved. So this is certainly an area that affects the rights of children, the rights of beneficiaries. So in the situation that this does not occur, does the court have any solutions regarding what might be recommended to a court that's handling an issue such as this?
Yes, so Florida has probate rule 5.120.
Love it.
And under this statute, the court may appoint a guardian ad litem to then represent a minor's best interest. And in case you didn't catch my emphasis, yes, appointment is discretionary.
Right, because it costs money.
Exactly.
And it's got to come from either the child or the beneficiary's estate.
Exactly. And so they're not required, but in establishing that representation for the minors, without it, they could be left without that safeguard. A guardian ad litem has no affiliation with either party. They're a neutral third party that can fully advocate for the child.
The eyes and ears of the court.
Yes, exactly. That's a wonderful way of putting it. So, they're investigating. They'll be reporting to the court on what is best interest for the child, and their role is essential in these cases of undue influence.
And well, as a matter of fact, there is a requirement of appointing of a guardian ad litem whenever there are funds that have been procured either by a wrongful death action of a parent or some other family member for the benefit of the child, so that the court has an input from a guardian ad litem as to whether the settlement is fair.
Correct.
And in that case, guardian ad litem are really the guarding angels of the children, again, so that the parents don't overwhelm and don't have the undue influence of taking money for themselves and for their own use, as opposed to, again, for the children and safeguarding that for them. So raising awareness matters.
Absolutely. And even if your only exposure prior to this podcast of undue influence is through a movie like Knives Out, it is still an occurrence, as you've established today, Judge, that happens in real life. Courts see cases where wills are manipulated, vulnerable testators are isolated, children's rights are compromised, and in addition to spreading awareness of the possibility of this happening, it is equally important for us to understand the solutions that protect the beneficiary's rights, including the appointment of a guardian ad litem in those cases.
Excellent, Alexandra. You've walked us through definitions, doctrinal tests, statutory authority, case law, all in digestible steps.
Thank you, Judge. I have really enjoyed learning more about this topic, and in my preparation for this episode, it has been an incredible learning experience, and what a gift to then be able to educate our community on this important information.
Well, I completely, wholly, tremendously, wholeheartedly agree. That's where we're going to leave it at this point. Thanks, everyone out there, for joining us in today's episode of Carving Out Undue Influence, the 10 Carpenter Factors Preserving Beneficiary Rights. And if you enjoyed this content and would like to hear more, don't forget to like and subscribe to the Studio 226 Orlando page. In closing, to those of you who are watching, listening, or both, we thank you for your time and hope that this podcast was helpful. This podcast is for educational purposes and not intended to provide legal advice. You should contact a licensed member of the Florida Bar to discuss your particular situation. Again, don't forget to like and subscribe to this podcast. Remember, you can find Aging Smarter, this podcast, on the Senior Resource Alliance website or wherever you get your podcasts. Join us once again next time for another episode of Aging Smarter from Studio 226 in Orlando. Y'all behave out there. And before we go, I want to give some kudos. I want to give some kudos to the person without whom this podcast would not be possible, and that is our showrunner, jack of all trades, Art Miles. He's been with us since the beginning, which now marks about a year. And also, I want to thank the person that cut my hair yesterday in preparation, and that's Jonathan M. Jonathan M., thank you very much. Floyd's on Fairbanks in Winter Park, you do miracles. You keep me from looking like I'm an unhoused individual. Thank you very much.